5 seconds to go. Start. Learned counsel for the appellant would submit that the magistrate himself, while taking cognizance, could have proceeded against the present appellant if he had been satisfied that the materials on record implicated the appellant to any extent, but when the magistrate opted not to proceed against the appellant, the High Court could not have issued directions to further reinvestigate the matter qua the appellant, though it is always open for a court to proceed against a person not sent up for trial at the stage of section 319 CRPC if the evidence is forthcoming in that regard. Learned counsel for the respondent number 3 has supported the impugned order with the submissions that the appellant was a high-ranking officer and he appears to have influenced the other officers in the internal inquiry so as to give him a clean chit. A copy of the audit report dated 31st May 2012, forming the basis of the FIR in question, has been placed on record and has been exhaustively referred to during the course of submissions. The learned counsel has underscored the observations of this court in the case of Vinu Bhai Supra that the ultimate aim of investigation and inquiry, whether by the police or by the magistrate, is to ensure that those who have actually committed the crime are booked and those who have not are not arraigned to face trial. With reference to these and other observations, that such requirements pertain to the spirit of Article 21 of the Constitution of India, learned counsel has argued that the offences in question relating to defalcation of food grains which caused hardship to the economically weaker sections of the society need to be properly investigated, not only to book the actual culprits but also to check the recurrence of such a crime. The learned counsel would argue that in the peculiar circumstances of this case, when it was found that no proper investigation was carried out against the appellant, who was the district manager and overall in charge of the godowns, the High Court has rightly exercised its inherent powers to issue the directions so as to ensure further and proper investigation in the matter. While relying on the decision of this court in the case of State of Punjab versus Central Bureau of Investigation and others 2011-9 SCC 182, the learned counsel has contended that under section 482 CRPC, the High Court has the power to order further investigation as also reinvestigation and that no illegality or jurisdictional error could be imputed on the order impugned. The learned counsel has further submitted that when the High Court has the power to direct further investigation or re-investigation directly, it also could do so by issuing directions to the learned magistrate who is in session of the matter. The learned counsel has further contended that the magistrate before whom a final report is submitted has the power and authority to differ with the report and to order further investigation. Stop.